Injury. 44. The word injury denotes any harm whatever illegally caused to any person, in body, mind, reputation, or property. Affray. 159. When two or more persons, by fighting in a public place, disturb the public peace, they are said to commit an affray. Punishment for committing affray. 160. Whoever commits an affray shall be punished with imprisonment of either description for a term which may extend to 1 month, or with fine which may extend to 100 taka, or with both. Chapter 5a. Criminal conspiracy. Definition of criminal conspiracy. 120a. When two or more persons agree to do, or cause to be done, 1. An illegal act, or 2. An act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. Provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Explanation. It is immaterial whether the illegal act is the ultimate object of such agreement, or is merely incidental to that object. Punishment of criminal conspiracy. 120b. 1. Whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards, shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished in the same manner as if he had abetted such offense. 2. Whoever is a party to a criminal conspiracy other than a criminal conspiracy to commit an offense punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine, or with both. Solitary confinement. 73. Whenever any person is convicted of an offense for which under this code the court has power to sentence him to rigorous imprisonment, the court may, by its sentence, order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in the whole, according to the following scale, that is to say, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months. A time not exceeding 2 months if the term of imprisonment shall exceed 6 months and shall not exceed 1 year. A time not exceeding 3 months if the term of imprisonment shall exceed 1 year. Limit of solitary confinement. 74. In executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time, with intervals between the periods of solitary confinement of not less duration than such periods, and when the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole imprisonment awarded, with intervals between the periods of solitary confinement of not less duration than such periods. Sedition. 124a. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards, the government established by law shall be punished with imprisonment for life or any shorter term, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Explanation 1. The expression disaffection includes disloyalty and all feelings of enmity. Explanation 2. Comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means, without exciting or attempting to excite hatred, contempt, or disaffection, do not constitute an offense under this section. Explanation 3. Comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection, do not constitute an offense under this section. marrying again during lifetime of husband or wife. 494. Whoever, having a husband or wife living, marries in any case in which such marriage is void by reason of its taking place during the life of such husband or wife, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Exception: this section does not extend to any person whose marriage with such husband or wife has been declared void by a court of competent jurisdiction, nor to any person who contracts a marriage during the life of a former husband or wife, if such husband or wife, at the time of the subsequent marriage, shall have been continually absent from such person for the space of 7 years, and shall not have been heard of by such person as being alive within that time, provided the person contracting such subsequent marriage shall, before such marriage takes place, inform the person with whom such marriage is contracted of the real state of facts so far as the same are within his or her knowledge.
Adultery. 497. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man, without the consent or connivance of that man, such sexual intercourse not amounting to the offense of rape, is guilty of the offense of adultery, and shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. In such case, the wife shall not be punished as an abettor. Fabricating false evidence. 192. Whoever causes any circumstance to exist or makes any false entry in any book or record, or makes any document containing a false statement, intending that such circumstance, false entry or false statement may appear in evidence in a judicial proceeding, or in a proceeding taken by law before a public servant as such, or before an arbitrator, and that such circumstance, false entry or false statement, so appearing in evidence, may cause any person who in such proceeding is to form an opinion upon the evidence, to entertain an erroneous opinion touching any point material to the result of such proceeding, is said to fabricate the evidence. Illustrations. A puts jewels into a box belonging to Z, with the intention that they may be found in that box, and that this circumstance may cause Z to be convicted of theft. A has fabricated false evidence. B makes a false entry in his shopbook for the purpose of using it as corroborative evidence in a court of justice. A has fabricated false evidence. C with the intention of causing Z to be convicted of a criminal conspiracy, writes a letter in imitation of Z's handwriting purporting to be addressed to an accomplice in such criminal conspiracy, and puts the letter in a place which he knows that the officers of the police are likely to search. A has fabricated false evidence. Thug. 310. Whoever, at any time after the passing of this act, shall have been habitually associated with any other or others for the purpose of committing robbery or child stealing by means of or accompanied with murder, is a thug. Punishment. 311. Whoever is a thug shall be punished with imprisonment for life, and shall also be liable to fine. Chapter 22. Of criminal intimidation, insult, prejudicial act and annoyance. Criminal intimidation. 503. Whoever threatens another with any injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested, with intent to cause to alarm to that person, or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do, as the means of avoiding the execution of such threat, commits criminal intimidation. Explanation: a threat to injure the reputation of any deceased person in whom the person threatened is interested, is within this section. Illustration: A, for the purpose of inducing B to desist from prosecuting a civil suit, threatens to burn B's house. A is guilty of criminal intimidation. Punishment for criminal intimidation. 506. Whoever commits the offense of criminal intimidation shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. And if the threat be to cause death or grievous hurt, or to cause the destruction of any property by fire, or to cause an offense punishable with death, or 157, imprisonment for life, or with imprisonment for a term which may extend to 7 years, or to impute unchastity to a woman, shall be punished with imprisonment of either description for a term which may extend to 7 years, or with fine, or with both. Criminal intimidation by an anonymous communication. 507. Whoever commits the offense of criminal intimidation by an anonymous communication, or having taken precaution to conceal the name or abode of the person from whom the threat comes, shall be punished with imprisonment of either description for a term which may extend to 2 years, in addition to the punishment provided for the offense by the last preceding section. Act of a person of unsound mind. 84. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Bribery. 171b. 1. Whoever I gives a gratification to any person with the object of inducing him or any other person to exercise any electoral right, or of rewarding any person for having exercised any such right, or 2. Accepts either for himself or for any other person any gratification as a reward for exercising any such right, or for inducing or attempting to induce any other person to exercise any such right. Commits the offense of bribery. Provided that a declaration of public policy or a promise of public action shall not be an offense under this section. 2. A person who offers, or agrees to give, or offers or attempts to procure a gratification shall be deemed to give a gratification. 3. A person who obtains or agrees to accept or attempts to obtain a gratification shall be deemed to accept a gratification, and a person who accepts a gratification as a motive for doing what he does not intend to do, or as a reward for doing what he has not done, shall be deemed to have accepted the gratification as a reward.